Welcome everybody to this week's Thursday night webinar. And this is the end of term, if you like, and this will be our final seminar for the summer. There will be a few more, I hope, coming over the summer, particularly in the lead up to the Paralympics. And then we'll be back probably in late September or the beginning of October to renew the series. But tonight we're going to focus on common legal issues and issues that groups need to be thinking about and that we're aware are common problems for groups. And I'm delighted that we're joined by Shivaji Shiva, who is, amongst many other things, RDA's lawyer. He is the charities partner for VWV and has worked with RDA, I think, Shivaji, for about 4 years or so, 4 or 5 years now.
Yes, that's about right.
And is very definitely a charity law specialist. Describes himself, I see, as a serial charity trustee, and is often seen riding, but I think on bikes, not horses, most of the time. So
I'm afraid so.
Welcome, Shivaji. I'm going to kick straight off, if I may. And I should say we've had a number of questions that have been sent in or posed as well. And if you have questions or queries on the way through this, please feel free to use the Q&A function and we'll pick those up and try and answer as much as we can as we go. But Shivaji, I was going to kick straight off with a topical question, which may be on many people's minds, but really is around the vaccine status of volunteers and riders of groups. And I think quite a few people would like to know what's the legal status or the ability for a group to act upon or indeed even ask about another person's vaccine status?
So I think my starting point for this is, well, first to say that I'm not an employment law specialist, but I'm going to start with employment law. And that's because it's a helpful starting point to think about what you do in relation to an employee or a team of employees. And as always, the concern is going to be keeping everyone safe. And I think that will run through thinking about volunteers and participants too. And the current legal guidance is that it's not compulsory to have the vaccine, and therefore that employers should be very cautious about seeking to make it compulsory for individuals to have a vaccine in order to do the job. And that before doing that, they should consider very carefully what the health and safety issues are. So in the context of an RDA group, I'd say, well, stick with that guidance, which is endorsed by, among others, ACAS, and be cautious about compelling vaccination, but also think broadly about how people are going to be safeguarded, and consider then whether roles can be changed to ensure that people who are not vaccinated are separated, kept safe in other ways. And that involves the interaction with thinking about where people are and whether we have enough open space to ensure that people are effectively socially distanced. Now, as you highlight, and time is too short to go into this in any detail, but there are a number of issues then for trustees to think about. And those include data protection. So how are you requesting information? Are you requesting only what you need to make the decision? And are you doing that in a way that gives people the chance to object? So I don't want to share that status, so that you can think about whether there's a basis for asking again and asking more firmly. And also the nature of the role, the views of the individual or individuals concerned, and once again, that wider sense of where the dangers arise. And that goes back to the understanding that the Charity Commission has of safeguarding, which is that safeguarding generally is not just about vulnerable adults or about children. It's also about making sure that everyone who comes into contact with the charity is kept as safe as is possible. Excuse me.
Yeah. Okay. Great. So really, on that basis, you don't have a right to know. But if people are willing to share, you could consider, for example, if they're having very close contact with participants, whether that's the best role for them if they haven't been vaccinated, someone hasn't been.
So what may be possible is to say for certain roles, it's necessary to be satisfied that it's safe, and therefore, in order to do that, you'll have to confirm that you've had a vaccination.
Mhm.
And that might, as you say, include being close to individuals, and so coaching one-on-one, for example. But before seeking to impose those requirements, it's wise to think about the wider picture. I suppose I should turn that around actually, Ed, and just ask, is RDA UK thinking about sending out some guidance to local groups?
Well, we've been responding to questions about that, and I think it might be a helpful area for us to put some specific guidance out. So, but I think, as you say, it's a bit of a grey area, and I think what RDA groups, I hope I'm right in saying this for all present here, but we're very good at thinking about and assessing risk, and understanding where there is a risk. And I would hope that within, absolutely, it's everyone's right whether they want to be vaccinated or not, but I'd hope people would also be willing to share that information and adjust accordingly. But
absolutely.
Going
you're going to
slightly
go on to
more.
another question, I know, Ed, but just before you do, to say that we've spoken and we've got some links to articles that we're going to be able to circulate afterwards. And one of those is on the issue of vaccination and staff.
Yeah. Okay. Yes. Brilliant. Well, as you say, following this, when we send out links to the recorded version of this, we will also send that list of information out to or links to good places to all groups. So those of you on this, you'll receive that hopefully in the next day or so. But I was just wondering, in terms of COVID's affected us in all sorts of ways, and it's put various strains on governance of RDA groups. So just broadening it a little bit, whether you think there's any particular lessons or particular sort of top tips that have come out of the last year from your point of view, from a charity law point of view.
Yes, I think there are a few, and I think the ones most relevant here are firstly that you mentioned strains, and we're seeing boards of trustees encounter internal disputes, arguments amongst themselves, more than is usual. And as it happens, my practice means I see a lot of these disputes, but I don't normally see them in organisations that deliver physical activity or the type of work that RDA groups deliver. They're normally in very specific pockets of the charity sector. And what we've seen is we've begun to see trustees disputes across a wider range of very well established organisations where we wouldn't normally expect to see them. And I think the assessment of the 6 or so partners in the charities team and others across the firm is that people are really suffering from the exhaustion of making decisions on really critical issues, some of them about the survival of the charity, on the basis of really uncertain facts and often changing regulation and law, not just changing law, but fast changing law, with the situation that, if we remember back to March last year, things were changing on an almost daily basis, but it was never quite clear what the rules are. And before you got to grips with one set, you had the next set coming through. And I think we're seeing, with the consideration of the Delta variant, the new variant of COVID, yet more uncertainty, and organisations are continuing. So there's something about providing space to manage uncertainty and acknowledging that disputes are sometimes inevitable, that people in good faith can disagree, and therefore recognising that that isn't something we say a lot in the charity sector, which is full of a lot of nice, well-meaning and well-motivated people who want to believe the best of others. And all of that's obviously very positive, but it does make us a bit slow occasionally to acknowledge a difference of opinion and recognise that perhaps that difference of opinion is beginning to get to the stage where the organisation is suffering. So there's something about getting those disputes out and then resolving them, and recognising that there are special rules for charities where disputes arise. On a more optimistic note, the other lesson I'd highlight, and it's not so much a lesson as a comment, is that we have seen over the last 6 to 9 months a lot of talk about building back better. about improving organizations. And I think that the crisis that we've been through is definitely an opportunity to improve organizations. It doesn't always feel like that. It often feels like a desperate struggle to keep organizations going in order to serve the people that we serve. But if there's a forced period of downtime, although it doesn't feel easy to do, there's an opportunity to rebuild, to think about whether we should be doing what we were doing before, or whether a different approach would be valuable. We've seen a lot of impromptu collaboration across the charity sector and wider. People just reaching out to help because they can and not worrying about the agreements and the rules and the formality, whether that's distributing food in your town or village, or getting out to check on people who you know need it. And I think that spirit can carry across to the voluntary sector, and thinking about working with other groups within RDA and potentially outside RDA to deliver the services that the people that RDA works with, the riders, need.
Yeah. Okay. Yeah, I think that's really interesting. We've certainly seen all of that in terms of stresses and disputes, but also in terms of increased partnership working and innovations and just speeding up new ways of working. And my favourite example I've seen is a group in Wiltshire who this will mean more to the attendees maybe than to you, Shivaji, but who have started using miniature Shetlands to long rein with kids aged about 6 to 8. So they're walking behind them, a bit like you might drive a plough horse, for example, but without the plough. And RDA people, come to the championships at Hartbury next year, and I hope you'll see the Wello RDA miniature Shetland long reining display team, which will be a new innovation. So moving
fantastic.
Yeah. Moving to a completely different area, Shivaji, a bit of work that we know a lot of groups have been concerned about for a number of years, and yourself along with some of your colleagues and one of our regional chairs has put a lot of work into, is around the importance of having some kind of agreement with your landlord, or, well, I use the term landlord quite loosely in our sense, the proprietor of a riding school. And in terms of the bit of work we've done, which I'm sure we'll both reference, but are there any particular observations that have come out of that work from your point of view?
Well, I think I'd start with an observation that carries out broader than that particular piece of work, which is, and again, it's about one of the joys of the voluntary sector, which is that so many people work together in good faith. And in this context, what that means is that often owners of riding centres, the owners of property which might be useful to a particular RDA group, have said, well, you can use this. I can let you in, and the group and the landlord, as we'll call them, as you say, have worked hard to make it work, and have often done a little bit of give and take from either side to say, well, I tell you what, if you can pay us for some lessons in the week, then that will help, or if you can give us so much time in the centre, and the result has often been really useful relationships that survived for a long time and have been to the benefit of both the centre as a way of keeping it going, enabling it to help, but more fundamentally to the group. The difficulty with that is that as these things continue, people change, volunteers get another enthusiasm, are able to have to move house, or riding centres evolve. Sadly, sometimes people get ill or die and they have to move on from either side. And as with many of the scenarios in which I and my colleagues work, I find myself saying, let's get an agreement into place, because you're absolutely right that with the person you're dealing with at the moment, it's probably okay. It isn't always, I've got to say, but it's probably okay, because you have a shared understanding of what was intended at the beginning and what it's fair to ask for and what's unfair and possibly legally improper. But when they move on, you're going to be a bit stuck, because the person who comes in will not have that same relationship. the child of the individual who owns the property, who has a different idea on how that area can be used, or a new set of trustees at the group who perhaps want to be a bit more ambitious about the use of the space. And it protects both parties to have a formal agreement in place that provides a structure, which hopefully you'll allow to go dusty on a shelf because you understand the day-to-day, but which can be called upon when it's essential.
Absolutely, and we've seen sadly one or two issues where that's gotten badly wrong for groups that have invested in a site and then found themselves without access to that site. And in terms of the process, I know you've been key, say with a colleague, of putting together some guidance which we hope to publish within the next week or so, and again will be referenced on the sheet that follows this. But to what extent is it necessary to get a lawyer involved in pulling an agreement like this together? I can guess your answer.
As with many of these things, it's possible to manage without a lawyer. But I suppose I'd keep it brief and say probably of the 10 cases, 10 projects that are keeping me busiest at the moment, the 7 of them have come out of instances where the individuals concerned, on both sides often, thought that they could manage without a lawyer because, oh, it's fine, we'll manage, it'll be okay. And in each of those cases, we're busy unpicking the very, very complicated result, with neither party being happy about what the result ended up being, and everyone being both annoyed and extremely frustrated at the cost that now results. And it's not very nice for anyone to say, I told you so, but I sometimes have to bite my lip when a client says to me, if I'd only done this, if I got a lawyer involved at the start, it would only have cost me X, but that is a tiny fraction of what they're now paying to untangle everything. And that's before we think about the personal relationships. It's, I think, a notable part of RDA's arrangements that many local groups have really close relationships with the people on the other side, as it were. Yeah. The landlords or the riding centre owners. And what you don't want to do is to jeopardize that relationship because there's a lack of clarity.
Mm-hmm. Yeah. Okay. So a clear message there, really. And one of the services that we can provide, and indeed I've done on a number of occasions for our groups, is if yours is a group where you have the situation of having had a landlord or a good relationship with someone for a very long time, and it feels a bit awkward to suddenly start suggesting it should be formalized, I'm more than happy to provide a robust letter in agreement with you that you can show to somebody else and say, it's not just me that is saying this needs to happen, but actually our national body is telling us we have to. So blame it on me, if you like. Just as part of that, someone's asked us whether you'd advise legal involvement when negotiating a new lease. So thanks for that, Debbie. Is that I assume that means if you're renewing a lease as well, would you advise getting a lawyer involved at that point?
Unsurprisingly, I'd say yes. And the reason for that is I think twofold. One is that it's often very difficult to negotiate with a party that you know in an objective sort of way. And the responsibilities of charity trustees are to the charity and through that to its beneficiaries. So they've got a duty to get the best deal for the charity. And they can take into account, to an extent, a limited extent, the benefits of having a good relationship with a landlord or whoever it might be. But it's really important to have that independent view, because otherwise, in trying to be nice, it's very easy for trustees to get into a situation where the landlord won't thank them, and more than that, the charity commission could be critical. So it's very important to have that independent view. And if it helps, and sometimes it does, it can be limited to having a look at the heads of terms, the summary of the key terms that are being negotiated, and that can be the starting point. so that if everything's absolutely clear and it's going to be fine, well, maybe people go away at that point and do a little bit more themselves. But there's an opportunity to sense check the relationship that's being suggested.
Okay. And then sort of partly moving on, but a related issue, which is a particular one I know within RDA, is around conflicts of interest, and particularly conflicts of interest with riding school proprietors, where they may have set up the group or they may host the group and be paid quite justifiably, be paid for their services by the group, but also not unreasonably want to be involved in the organisation and some of the decisions made about how the group's run. So I don't know whether you've got any thoughts about the best ways of managing those.
Yes, and I think it's worth summarising. This is a very crude summary, but summarising the Charity Commission's general position as being that it's not in itself a bad thing that there is a conflict of interest or a potential conflict of interest. The problem is in failing to manage the conflict of interest. And the first step in managing a conflict of interest is for everyone to acknowledge that it exists. So to have the disinfectant of sunlight, as it's sometimes put, to ensure that everyone knows what the interest is. And that's uncomfortable occasionally, to say, thank you very much for your help over 10, 20, 30 years to this group. But I just need to point out that you've got your own interests, which might differ from our groups. However, once that embarrassment has been moved past, acknowledging conflicts of interest in that way enables the group to ensure that the charity trustees and through them its beneficiaries are protected, and enables the individual concerned to protect their own position, which might be critical to the success of the centre and therefore to the success of the group. And it's important to recognise that the Charity Commission's view of conflicts of interest has hardened, and in the worst case, the transaction that would otherwise have happened without that embarrassing exchange would be invalid if there was a fundamental conflict of interest there. So it's best that for everyone involved, for those conflicts of interest to be number one, acknowledged, and then managed appropriately, which might be as simple as asking a landlord who's also on the board to remove themselves from that particular decision, or might involve some slightly more elaborate steps around minuting and managing decisions. But in any event, the starting point is recognizing the conflict and then declaring it openly.
Okay, yes, and doing that while everyone's still friends is the easiest way to do it, isn't it? So
Absolutely.
yeah,
Absolutely.
absolutely. And I think another one that's common within RDA as well is having family members on a trustee board as well, and again, just recognizing that could be a problem is worth doing before it is one. Okay.
Absolutely.
And something that's come up more recently and over the pandemic as well is the extent to which an RDA group can provide any financial support for a riding school that it's based in. And I think this is quite a tricky issue, but I was wondering whether you had any thoughts around that.
Yes, and first of all, I should say I can understand why RDA groups, their trustees and volunteers, want to help the centres they might have been based in for many years. It's an entirely understandable human reaction, but it's important to remember that only one of those two entities is likely to be a charity. The RDA group will almost always be a charity, and the centre is a commercial entity fundamentally. And however benevolent the relationship has been, in putting money into a commercial entity, there is a risk of private benefit, which is the phrase that the Charity Commission would use. And that private benefit is not a proper target of charitable expenditure. So it's not entirely impossible to fund a commercial entity, but the group needs to be satisfied that the nature of the project being funded, the activity being funded, is itself charitable. And here, I think this is another area where national office support is probably going to be helpful, because you need to get some form of third party to have a look to say, does this make sense to you? That sort of sense check. And if someone can look at it and think, I can understand that. You know, perhaps it's the delivery of a particular set of activities that the group could not deliver itself, but are clearly things that the group would deliver if it could, a particular form of training, for example. Then there might be the prospect of providing that support. And the next step would be to say, are we giving them too much money for that? So I'd say, first of all, recognize that, again, there's a potential conflict of interest, that there's a risk of private benefit, and that there are ways of getting help, whether from some RDA UK or from an external advisor or professional.
Okay, brilliant. And then I know this is quite a big issue, and I know you're not particularly an HR specialist, but one of the issues we are asked about and have been is the increasing number of groups that have either employees or are using freelance coaches, so self-employed freelance coaches who they pay, and just really wondering if there are any specific issues that groups need to be thinking about if they're moving towards either freelancers or employees within their groups.
It's an important question, and it's one that's been an issue for charities for a long time. The starting point is to say, firstly, ensure that you're getting good advice. If this is a first time engagement, a first employee, a first consultant, it's important that the employment contract is well drafted and ideally does a bit more to protect the group than a simple statement of particulars of employment might do. So you can look up online the minimum requirements on the government website, and that won't protect you as much as it should. The second thing is that it's very easy for individuals to drift between those categories. So having either an employee with the full bundle of rights that you can expect as an employee, or a worker who might have some of those rights, or a volunteer who in theory has just none of them, or very few of them, I should say. And the challenge is that an employment tribunal will look at the substance of the relationship, and they won't look at how you've labeled it. So you may have someone who you describe as self-employed, but who works for the group in a way that is characteristic of an employee, who is always there for the same hours, who you rely on to do the job themselves, not ask someone else to do it, and who comes to you for instructions rather than agreeing a brief in advance, for example. And there are a range of these characteristics of employment. And if they begin to exist, then even if you have a really clear agreement with self-employed emblazoned across the top of it in large capitals and bright red, an employment tribunal may conclude that you've got an employee in fact, and may then require you to provide the holiday pay that you would not otherwise have to pay, and to provide the other rights that go with employment. And clearly, if you haven't budgeted for that, that's a bit of a nasty shock. And similarly, if you have a volunteer, but you begin to let them drift into a scenario where they're expected for specific hours of time, that they're expected to deliver a job, not just, you don't just hope that they do, but it's seen as an obligation, or that there's a flat fee for some of what they do, described perhaps with the sort of euphemistic terms we use from time to time, like an honorarium or something similar, then you might find that that individual is able to claim that they are either a worker or an employee. And again, they would then have a bundle of rights which you might not have anticipated. So it's worth reviewing from time to time which category individuals come in. And if there's any doubt, then seeking some guidance, either from central office or through the legal helpline, would be a prudent thing to do.
Brilliant. And thank you, Shivaji. That was a perfect segue into the final point I wanted to make, which is about the legal helpline, which I think you're on the receiving end of. But do you want to just explain a little bit about what that is and how it works?
Absolutely. So there's a phone number that's distributed and that will be with the materials you get after this session. And any RDA group can give that number a call and can get a 15 minutes, I think we say, discussion in general terms about a particular legal issue to help them understand what the legal issues are and how it might be dealt with. Now, because I don't have a direct relationship, or we don't as a firm have a direct relationship with those groups, we can't give specific legal advice, but we can almost always provide guidance, a direction towards sources of help, an indication of what the general legal principles are, and a broad assessment of the level of risk. So commonly it might be someone calling up and saying, I have this issue with an employee, what do I do next? And we can begin to point them in the right direction. It might be someone saying, I'm a little bit uncertain about the relationship with our centre owner. What could we do about it? And we might point them to the guidance that Ed was mentioning earlier, or to a model set of heads of terms for such relationships, so they can begin to develop it. And although I'm not an employment lawyer, and I'm not many other things in terms of law, we're lucky to be a full service law firm, so I can almost always pick up the phone to someone with the right set of expertise and just get things started. And if there is a need to go beyond what we can offer through the helpline, then we can do two things at that point. We can provide an estimate of the cost of direct legal advice and an indication of how we would deal with it. And we can also direct groups where it's appropriate to talk to Ed and the team and say, well, we've got this problem and we haven't got a budget for it, or we're not sure about it. Is there any way you can help? Ed, I know you'll want to say that you can't always help, but I know that there'll be a good effort to try and to help frame the problem.
Yeah, exactly. And I know there are several groups out there that have done that and indeed are involved in that sort of process at the moment. And I think yeah, we've heard a number of instances this afternoon or this evening where it's really important to get good advice, and I would encourage people to make use of that. And sometimes it's worth just checking and understanding. So we've slightly overrun the end of our half an hour. So Shivaji, thank you very much indeed for your time and for providing that. I know we are hoping that we might reprise this kind of thing later in the year and maybe pick up some other issues. But as has been referenced a number of times this evening, there will be a sheet coming out with some links to get some advice to some of these specific issues, and look out for the excellent guidance on leases and agreements with landlords that will follow this. But so thank you very much for that, everybody, and thank you, Shivaji. And
thank you very much, Ed, and everyone.
Thanks. All right. Bye-bye.
Good evening.